Chapter 2, Credit Transactions, General Requirement of the Disclosure. Each creditor shall disclose clearly with the constitution of the code of the regulation of the board, each in person with the consumer of the credit extent of the information required under this chapter or chapter 4. If there is a person with the obligator with the credit with not furnished with the same of the information required within this chapter 2 or chapter 4 or more than one of them. Repeal of Public Law 94-205, approved January 1st, 2nd, 1976, 89, Statute 1169. 122. Form of the disclosure and additional information regulation of the board and do not for the disclosure pursuant to the chapter 4 made with the order of the set forth in chapter 4 set in this chapter or in chapter 4 may permit the use of the terminology different than employed with the chapter 4 and conveying the subsequently substantially with the same and even any creditor may supply with additional information explanation with the disclosure required in chapter 4. 123. Exemption of the state regulated transaction board shall regulation exemptive of the requirement of the chapter for the any close with the transaction class with credit with the transaction within any state evidence determines if the law with the state with the class transaction with the requirement is substantially similar to those imposed within this chapter for that there's adequate provision for enforcement. 124. Effective subsequent occurrence of the information disclosed in accordance with the chapter for the subsequently rendered inaccurate with the result of the act. Occurrence and agreement is subsequent to delivery of the required disclosure and accuracy of the result of the error does not constitute the violation of the chapter 125 of the report right of the precision of certain transactions. Obligator's right to resign, except the otherwise provided with the section with the case of the consumer transaction with the security interest, including such the interest arising from the operation by operation of law or is by will, retain, or acquired in real property, which if it is or is expected to be the residence of the person to whom the credit is extended to the obligator shall have the right to resign with the transaction until the midnight of the third business day following with the consumption of the transaction delivery. Disclosure required under section all of the other material of the disclosure required within the chapter which have laid the notifying of the creditor within accordance with the regulation on the board of his intention to do so. The creditor shall clearly conspicuously disclose in accordance with the regulation of the board that any obligator in transaction subject for the over the section rights of the obligor under this section, creditor should also provide, in accordance with the regulation of the board, adequately opportunity the obligator to exercise his or her right resign in any of the transactions subject to the section. The obligator exercises the right to resign under subsection A but no liable for the finance any other charge and security interest given the obligator with the include with such interest as arising operation law with become void upon such recession. Within 10 days after the receipt of the notice of the recession, creditor shall return the obligator with any money, property given with the earnest money, down pay, otherwise shall take any of the action necessary with the appropriate to reflect with the termination, subsecurity, interest credit under the transaction, creditor to live with the property for the obligator may retain possession over the performance of the credit obligation over the chapters of the obligator with the over the tenant of the property for the credit except if the return of the property for the would be with the impractical, the inequitable with the obligator the shall the tender with the responsible value with the tender with the shall be made with the location of the property, the resident with the obligator with the option with the obligator with the credit but it does not take with the possession of the property within 10 days with the tender with the obligator with the ownership of the property with the vests and the obligators without obligation on the part of the pay for it. Notwithstanding any of the rule, evidence, written acknowledgement, received any disclosure required from the person who with a statement that is required to give it the pursuant of the section does not more than create the rebuttal with a presumption of delivery thereof. Modification or right of the board may, if it finds such action necessary to permit homeowners to meet with a bona fide personal finance and emergency prescribed with the regulation, authorized modification or waiver any rights created under the section extent of the under circumstances set forth in those regulations. This section does not apply with the creation, redemption, first lien, but against the dwelling with the finance acquisition dwelling with the consumer with the credit transaction, which agency with the state is with the creditor. The obligator's right with the possession shall expire with 3 years after the date of the consumption with the transaction upon the sale of the property whichever occurs ever notwithstanding the fact with the disclosure required under section 8 of the other material disclosure required under the chapter that may have not been discovered to the obligator. For the content of the periodic statement, if the creditor transmit periodic statement in connection with any extension of the consumer credit, or then under the open-ended consumer credit plan with each of the statements shall be set forth with the following items: annual percentage rate with the total financial trial for the date of which for the period, if any, with the payment must be made in additional information, finance charge, or any other charge of such items than set forth in section 127 of the board, but may regulation requirement of appropriate term condition under which extension of the credit is question is made. 127. Open-ended consumer credit plans. Required disclosure creditor. Before opening an account under an open-ended consumer credit plan with the creditor shall disclose the person to whom the credit will extend each of the following items of applicable condition under the finance charge may be imposed, including the time of the period if any with any of the credit card extended with may be repaid without incurring with the finance charge, except the creditor may and his election without disclosure imposed no such finance charge and if the payment is received after the termination of such time period. If the termination of the balance applied with the finance charge is imposed with the method of the termination amount with the finance charge is included in minimum of the fixed amount of imposed with the finance charge. Whether one or more periodic rates may be used for the compute of the financing charge, each of the rate with the range of the balances to which for the applying with the corresponding with the nominal annual with the percentage rate determined the multiplying with the periodic rate with the number of periods in the year. 5. If the creditor so elect the average effect for the annual percentage rate with the return of the receipt of the accounts for the under the plane of the representative of the period of the time or whenever the circumstances such for the computation rate with the subparagraph of the with the dot and be feasible with the practice with the would be misleading, meaningless. List of the projected rate with the return received from the accounts of the end of the plan with the board shall prescribe with the regulation consistent with commonly accepted with the standard of the accounting statistical procedure to carry out for the purpose of the paragraph of the condition under which of any of the other charges imposed with the method that may be to which they will determine the conditions under the creditor may retain and acquire security interest of any of the property to secure for the payment any of the credit extended with the under the display with the description of the interest or interests which may be sealed with the pertaining and acquired with the statement that prescribed with the regulation period board of the protection provided in section 161, 170 the obligator with the creditor responsible under section 162, 170 with respect with each of the two billing cycles with the first year with the semi-annual intervals with the creditor shall transmit such statement each obligator to whom the credit is obligee with whom the creditor is required to transmit statement in pursuant with the section 127b such billing private with the creditor with the any of the under of the open end of the credit card plan shall transmit with the obligee for each of the billing side with the end of which for the outstanding balance of the account with respect to the finance charge with imposed with the statement that for each of the following items extend the applicable outstanding balance account with the beginning of the statement period, the amount of the date with the extension period with the term of the period with the brief identification accompanied with the statement that each of the extension of the credit with the form with the prescribed with the regulation board of station with enable to obligate to identify with the transaction relate with the copy of the voucher some of the instruments previously furnished for the total amount of the credit to account with during the period. For the amount of the finance charge added with the account during the period with the itemized show with the amounts if any of the due with the applicant for the percentage rate with the amount if any of them imposed with the minimum fixed charge. 5. When more than one periodic rates may be used to compute with the finance charge each of the rate of the range bands for the which for the applicable with the unless the annual percentage rate determined under section 107.82 is required to disclosure pursuant to paragraph 6 of the corresponding nominal annual percentage rate determined the multiple periodic rate with the number of periods in the year. When the total finance charge exceeds 50 cents of the monthly longer bill cycle with the prorated with the 50% billing cycle shorter than the monthly total financial charge imposed with the percentage rate determined under section 107A2, except if the rates if the financial charge some of the two or more products for the rate of the time portion of the balance of the creditor may allude with the disclosure of the single rate for a total charge disclosing each such rate with expressed annual percentage rate with the part of the balance of with the applicable. After the election creditor, the average annual percentage rate with the return with the projected rate with until the plan with is prescribed in subsection A5. A, the balance of which the finance charge was computed in the statement that however the balance was determined if the balance determined the first deducting all of the credits during the period of the fact of the amount of the payments also for the discover the outstanding balance of the account with the end of the period. 10 the data without with which for the period everything within the payment must be made avoided for the additional financial charge except for the creditor made with the after the election without disclosure imposed without the additional financial charge if the payment received after such a date with the termination of such period with the directly used in the creditor for the purpose of receiving the billing requirements for the obligator obligated in the case of the existing account under the any of the open-ended credit open-ended consumer credit plan with having the outstanding balance for more than $1 after the close of the creditor first bill and full billing cycle with the owner of the plan effective with the effectivity of subsequent A any amendment thereto the items prescribed in the subsequent extent when the applicable is not previously disclosed shall be disclosed with a notice of mail but delivered to the obligees no later than time of the mailing of the next statement required by subsection B. 128. Sale of not under open-ended credit plans in connection with each of the consumer credit sale of the not under the open-ended credit open-ended credit plan with the creditor shall disclose each of the following items applicable to the cash price of the property and for the purchase, some of the amounts credited for the down one payment, including any trade-in, difference between any amount referred to in the paragraph 1 and the amount referred to in paragraph 2. All other charges individually itemized with which are included with the amount with the credit extent with which for the non-pro with the finance show with the total amount with the fines for the sum of the amount with the described in the paragraph 3 plus the amount with the described in the paragraph 4, except in the case of the dwelling with the amount of financial for the charge remaining with the whole and with the part of the designated with the time and the price for the differential for the same single similar term with the extent with the applicable finance charge expressed as the annual with the percentage rate, except in the case of the finance charge of which of the not exceed $5 applicable to the amount of the finance not exceed $75 or which does not exceed $7.50 is applicable to the amount of the finance exceeding $75. The creditor may not divide with the consumer credit plan sale in two or more sale to avoid the disclosure of any annual percentage rate with the presumed in this paragraph with the number of the amount with the due dates, period payments for the schedule for the repay with the indebtedness with the default with the delinquency, similar with the charge with the payable with the event with the law payment event over the late payment of the description of any security interest with the help with the retain and acquire with the credited transaction with extension of the credit, clear identification over the property with which security exchange release, interest rates, and except the otherwise provided in the chapter the disclosure required in subsection A shall be made at the end of the before the period of the extent of the may be made with the disclosure information contract with the other evidence indebtedness to be signed by the purchase of the if the creditor received the purchase of the order by mail, the telephone without personal solicitation with the cash price for a payment price and the terms of financing include with the annual percentage rate with the set forth on the creditor catalog of the printed material that is distributed to the public and the name of the disclosure required on subsection A may be made with the time no later than the day of the first payment is due. 2D, if the consumer credit sales to the point of the street of the consumer credit sales transaction pursuant to made with the agreement to provide with additional but deferred payment to provide for the sale of the existing outstanding balance of the person to whom credit standards approved proof of the written both of the annual percentage rate and the method of the computing of the financial charge or charges, and the creditor retains no security interest in property with which they has received the payment the aggregate with the amount with the sale of the price for the included in any financial charge attributed to thereof to the disclosure required in subsection A for the particular sale of the may be made with any time no later than the day of the first financial charge attributed thereto with the disclosure required in subsection A, the particular of the sale of the may be the time no later than the day of the first payment of the sale of the due for this person in subsection in this case of the purchase for the different day of the first purchase shall the deem of the first paid. In the case of the items purchased for the same day, the lowest price. Alright, the lowest price shall be deemed first paid for. 129. Consumer loans not under open-ended credit plan. Any creditor make for the consumer loan of the widest extent with the consumer credit with the transaction daily with the consumer center credit sale under any open-ended with the credit plan shall discover that each of the following items the extent of the applicable with the amount of the credit which the obligator will have with the actual use which will paid for him to his account with the other person on the behalf of all the charges individually itemized which are included with the amount of the credit extent of it which are not part of the finance charge. The total amount of the finance for the sum of the amount of the referred in paragraph 1 plus the amounts referred in paragraph 2 except in the case of the loan with the security of the first lien with the dwelling with the major finance the purchase of the dwelling amount with the finance charge expressed with the annual with the percentage of the rate in the case of the finance charge with the A which does not exceed $5 applicable with the extension of the consumer credit but not exceeding $75 which does not exceed $7.50 applicable with the extension of the consumer credit exceeding $75 and the credit may not divide the extension of the credit into a more transaction void with the disclosure of an annual percentage rate pursuant. This paragraph with the number of amount with the due dates period with the schedule of the repay with the indebtedness with the default with the delinquency similar charges payable to event layer payments. Description of any security interest to help with the retain and accord with the credit with the connection with the extension of the credit with the clear identification of the property to which security interest relates. With extent of the otherwise provided in the chapter the disclosure required in subsection A shall be made with the flow of the credit extent of the may be made with the disclosure information note with the other L of the indebtedness to be assigned with the obligator. Disclosure request for the extension of the credit. If the creditor received the request for the extension of the credit mail over the telephone without personal solicitation, term of the fine should include the annual percentage rate of the representative amount of the credit and set forth within the creditor's printed material that is distributed in public and with the contract along with the other printed material delivered for the obligated with the disclosure required under Subsection A may be made within any time and no later than the day of the first payment due with this 130 civil liability, except for the otherwise provided in Section A of the creditor who failed to comply with the requirements imposed within Chapter 4 or 5 of the title with respect to the in-person liable for the person amount with equal to the sum of 1 the actual damage of the sustained such person result of the failure with 2 a 1 in the case of the individual action, twice the amount with the finance charge with the connection with the transaction, or 2 in the case of individual action only with the consumer to leave at the under with the Chapter 5 with the title with the 25 with the percent of the total amount with the monthly payment of under the lease, except that the liability and with the subparagraph shall not be less than 100, no greater than 1,000. In the case of the class action, such amount of the court may allow with the extent of each of the member of the class with no minimum recovery shall be applicable with the total recovery and shall the action shall not be more than the leaser of the $5,000 lesser of $500,000, 1% same with the net worth over the creditor in case any successful action when the enforced foregoing liability with the cost of the action together with a reasonable attorney with the fee with determined in the court, determining the amount of the award for the case ass action with the criminal shall be considered the money relevant factors amount with the actual damages award with the frequency, persistent, the failure with the complying with the creditor. Resources of the creditor, number of the person adversely affected with the extent with the which of the creditor's failure with the compliance with his unintentional. B. Correction over the error. Creditor with non-liability under Section 80 failure with the comply with the requirement in both the Chapter or the Chapter 5 within the 15th day with the discovery the error of the right of the institution action for the end of the section from the receipt of the written over the error with the creditor with the notified with the person concerned with the error with the makes of the weather adjustments in the appropriate account with the necessary to ensure the person will be not required to pay such a charge in excess of the amount with the percentage rate with the actual disclosed. Bona fide error of the creditor may not be held liable to any action brought into the section violation of the title with the creditor shall show by preponderance of the evidence of the violation of the not intentional with the result of the bona fide error without understanding but the maintenance of the procedure reasonable adaptive with the avoid with any such area. Liability is subsequent assignment of any action with the brought under this section against the original creditor with the end of the credit transaction involved with the security interest with the real property may be maintained against the subsequent assigner with the original creditor whether the assigner with the subsidiaries affiliates were continuing business relationship with the original credit either with the time with the credit was extended at the time of the assignment unless the assignment is involuntary with the assigner shows by preponderance evidence if it does not have the reasonable grounds to believe that the original creditor will engage in the violation of the chapter of the same procedural response adapted to do the appraise with the existence of such violation jurisdictions of the court, any of the action of the section brought with the United States District Court, any other court with a competent jurisdiction with 1 year from the day of the occurrence of the violation, good faith compliant with no provision section 112, 112 with imposing liability shall apply with any of the act done with the admitted with good faith conformity with any of the rule, regulation, interpretation thereof by the board, in conformity with the interpretation of the approval of the official employee or of the employee of the federal reserve system duly authorized to the board for the issue of the interpretation approval of the owner as such proceed with the board may be described therein as notwithstanding thereafter such with the obmission occurred with such rules, regulation, interpretation, approval of the amended with the resign determined by with additional other authority with invalid any of the reason. Chief of the multiple fact failure to disclose any of the personal information required with the chapter 4 or 5 of the title of the disclosure connection with a single account with the under for the open consumer with the credit plan, other single the consumer the credit sale, consumer loan with the consumer leave, the other extension of the consumer credit shall extension entitle the person with the single the recover the section with the continued failure with the disclosure for the after the recovery has been granted and shall the rise of the rights for the additional recover the person may not take it in action also with the amount with the creditor potential liability such person in subsection 18 with against for the among with the owing with the creditor by such a person unless the amounts of the creditor liability such person is determined of the judgment of the court of the common jurisdiction any action in which of the person was a party. Written acknowledgement and proof of the receipt is accepted to provide in section 125C with accepted in the case of the action brought under section 130D when the action proceeding against for the subsequent assigner of the original creditor without knowledge of the contrary of the assigner with when the accords the obligation of the written acknowledgement of the receipt of the person's statement is required to give the pursuant of the title shall be conclusive with the proof of the delivery thereof unless the violation apparently faced with the statement and with the complying with the chapter of the section does not affect the rights of the obligator with any action against the original creditor. 132. Issuance of the credit card. No credit card shall be issued except if the response of the request for the application thereof. The prohibition does not apply with the issuance of the credit card within renewal of the substitution for and except the credit cards. 133. Liability for the holder of credit. The credit card holder shall be liable for the unauthorized use of the credit card only with the cards for the accept of the credit card with liabilities in excess of $50. Card issue for the give of the adequate notice to the card holder, potential liability of the card issue, provided the card holder scope the for the previous stamped. Notification to be mailed by the card holder to prevent the loss of the theft for the credit card. Unauthorized use of the cards before the card is notified with the card issue for the unauthorized use of the credit card has occurred, may be occurred with the result of loss of the theft for the otherwise notice. Notwithstanding foregoing that no credit card shall be liable to be unauthorized for use for the name of the credit card which is used for the and after the effective date of the section after the expiration of the 12 months following such effective date with the no credit card shall be liable to be unauthorized use for the name of the credit card. Over the day of the issuance and left the one, the condition of liability specified with the preceding sentence of the meet within two, with the card issuers have provided the method whereby with the use of such card can be identified with the person authorized to use it for the purposes of the section card noticeable with the card issue with the taking such steps. You may be reasonably required for the ordinary course of the business to provide with the card issue with the pertinent information whether or not any particular officer, employee, agent with the card issue does in fact receive such information. Any action with the card issue enforce the liability to use for the credit card with the burden of the proof is upon the card issue that you show that the use of it was authorized, or if the use was unauthorized, with the burden of proof upon the card issue to show if the condition of liability unauthorized use for the credit card set forth with the subsection A have been met. C. Notwithstanding the section with the input for the liability on the credit card or unauthorized use for the credit card except for the liability for the under the other applicable law under the agreement with the card issue with except for the provided section when the card holder incurs no liability for the unauthorized use of the credit card. 134. For fraudulent use of the credit card, whoever the knowingly transaction effective in the interstate with a foreign commerce with an intent to conspire with and use any counterfeit with the fictitious, altered, forged, lost, stolen, fraudulent, obtained credit card to obtain money, goods, services with anything the value within 1 year period with the value aggregating $1,000 or more. Whoever the unlawfully fraudulent intent with the transport, the intent with the conspire with the transport, with the interstate with the foreign commercial, with the counterfeit, with the fictitious, alterated, forged, lost, stolen, fraudulent, obtained credit card knowing the same with the counterfeit, with the fictitious, altered, forged, lost, stolen, or fraudulent, obtained, or whatever. With unlawful fraudulent intent with the instrumentality industry with the foreign commerce to sell with the transport, counterfeit, fictitious, altered, forged, lost, stolen, fraudulent, obtained credit cards knowing the same without the counterfeit, fictitious, altered, forged, lost, stolen, or fraudulent obtained. Whosoever knowingly receives the conceals the use of the transport money, goods, and services to anything, any use of the value with except with the ticket with the interstate with the foreign transportation, which with any 1 year period has a value aggregating $1,000 or more, has moved in with the part of the consistency with the interstate with the foreign commerce for the 3 that has been obtained with the counterfeit, fictitious, alterated, forged, lost, stolen, fraudulent, obtained with the credit card, who has been knowingly received the conceal the use of the sale with the transport, interstate with the foreign components, one more with the ticket, interstate with the foreign transportation, one within 1 year period have a value aggregating $500 or more, 2 that have the purchase obtained with more and more for counterfeit, fictitious, alterated, forged, lost, stolen, fraudulent, obtained credit cards. Whosoever the transaction affecting with the interstate with the foreign commerce with the furniture value of the property with anything unless of the value with any with a 1 year period value aggregating $1,000 or more throughout the use of the counterfeit, fictitious, altered, forged, lost, stolen, fraudulent, obtained credit card known with the same of the counterfeit, fictitious, altered, forged, lost, stolen, fraudulent, obtained shall be not fined more than $10,000 or imprisoned not more than 10 years or both. 135. Business credit card with the exemption of the provided with section 104B and 1. Does not apply with the provisions section 132, 133, and 134 except with the card issue for the business other organization provide with the credit cards issued with the same card issued with the 10 or more of its employee with the maybe the contractor agree with the liability with the business out of the organization with respect with the unauthorized use of the credit card without regard to the provision section 133, but in no case for the side of the business of the other organization over the card issue with the imposed with the liability with the present employee with respect to the unauthorized use of the credit card except in accordance with the subsection of the limitations section 133. Chapter 3. Credit Advertising.